Good afternoon, everyone. My name is Emily Mack. I am a partner at Burr& Forman here in Nashville, Tennessee. And today we are going to this is a two-part series on how to conduct a workplace investigation. We're going to do the webinar today, and then I hope that everyone will come on December 4th to the in-person second part of this series, which is going to be more of a practical application of some of the things that we're going to talk about during this day's session. This is a workshop, a kind of revamped workshop that we did at the state conference. And so if you missed it there, then we're very happy for you to join us today as we talk through conducting workplace investigations. This is something that, as attorneys, we are frequently called on to help our clients with, whether that is ourselves getting engaged to handle some type of a workplace investigation on behalf of a client, or simply helping employers navigate those investigations from a fact gathering through the witness interviews, through documenting the investigation in order to give them guidance on the back end for handling these types of situations. So we're going to dive right in here. Why are investigations necessary? If you've ever heard me speak before, you know that I say time and time again, and I'll probably say it at least 3 times today, that if we don't have anything in documented, then it's as if it never occurred. And investigations are a critical piece of the employment law framework, where having good, solid documentation can make or break your case when it comes to compliance, when it comes to obtaining a summary judgment motion. And when we're doing any kind of investigation, documentation is an important piece of it, because if we don't have anything to show in terms of what we investigated or how we responded to a complaint, it's again as if it did not even happen in the first place. So, we certainly, in addition to that, want to have an informed basis for decision making. If we think about employment law claims, if we think about achieving compliance and employee retention and having a good workplace that employees want to come to and want to stay at, it's incredibly important for us to be fair and to apply policies in a consistent manner. And doing sufficient, adequate investigations is a part of making sure that the employer's policies are applied correctly and fairly, and that we're not haphazardly making knee-jerk reactions. And so it's important to facilitate that unbiased review of when we think procedures may have been violated or policies may have been violated. And so it also reinforces that adherence to the company's mission and values. There are going to be certain circumstances where an investigation may not legally be required, right? We're going to talk about when it is and when it isn't. But even if it's not legally required, having an investigation before an adverse employment decision is made is important, because it provides that, again, level of fairness for employees to understand that they're being treated fairly, which is seen by coworkers and is something that kind of goes back to the company's ethos, mission, and values. Of course, doing adequate investigations also reduces claim exposure and potential liability. In some instances, they are legally required. Title VII, THRA, any kind of anti-harassment violation, and others that we will talk about, we have an affirmative obligation as the employer to actually take prompt and effective remedial action to redress any instance of unlawful discrimination or harassment that is occurring in the workplace. If we do not do a prompt investigation, then we are deficient in that area of the law, irrespective of whether or not the harassment occurred. So doing these is also a legal obligation under these statutes and is necessary if a claim is brought involving harassment, discrimination, retaliation, in order to show that the employer responded appropriately to it. If we go back and think about the way that these cases eventually, if they are brought, get tried, at one point you may end up in front of a jury as an employer trying to defend that your actions were appropriate. If we have not done an investigation and don't have anything to show for it, the employer is going to be at a disadvantage when it comes to disproving what the employee is accusing the employer of doing in these situations. So they also serve as a defense to wrongful discharge claims by showing that we had a good faith belief. There's a lot of good case law that says that courts will not sit as a super personnel department over and second guess the decisions that an employer has made. And so, one of the things that I'm going to talk about today and that we're really going to hit on during the workshop that involves kind of some hypotheticals and working through real life types of complaints and how you would respond to those is going to be, what do we do when the evidence is not it's not clear cut, it's inconclusive, and how do you respond and make the right call as an employer? And one of the things I want you to walk away with today is knowing that if you follow your process and if we follow the steps of being thorough in our investigation and how we approach it, then the outcome that we reach isn't necessarily as important. As an employer, you are not legally required to get it right, so to speak. But you are required to have a process and reach a decision based on the information that's available to you. And as long as you are acting in good faith when you do that, then we will have a solid defense to any claim that gets brought by an employee that attacks or challenges that decision-making process. So it's critically important to, again, go through the steps on this. And even if the ultimate decision or outcome that is reached is not necessarily accurate, or a different employer could have reached a different outcome, so long as we are acting in good faith, and then it is a good defense to these types of claims, right? So when I talk about these, oftentimes too, it the juries again want to see that this type of documentation exists. If someone makes a serious accusation, even if they've made other accusations in the past and they are a constant complainer, it is important that the jury knows that each of those is handled and dealt with appropriately by the company. And that helps defend these types of claims as well. In some instances, we know that workplace investigations are actually legally required. So obviously, any type of protected status or protected activity under Title VII or THRA, the Tennessee Human Rights Act, or any other state analog to that, any type of unlawful harassment, discrimination, or retaliation must be investigated. We have an affirmative obligation to do it, and failing to do it subjects the employer to liability. We do not have discretion in these situations. Now, you may say, well, what type of investigation should I do? Or if I don't have a lot of information, or if the employee doesn't want to participate, and we'll talk through what to do in those situations and really how to document. Even when we are unable to do anything more, there could at least be some documentation that goes with that to be able to demonstrate why that was the case. Another thing I want to talk about before we get too in the weeds here is timing. Because as we know, with any kind of employment claim, there can be a very long tail on these types of incidents. We may have an investigation that happens, let's just say in 2025, and, an outcome is reached. The employee, if they decide to further challenge that decision or the outcome of that investigation, has 300 days to file their charge of discrimination with the EEOC. It can sit there for 6 months or longer. I've seen it sit there for a couple years before. It depends on the office. It depends on their caseload. Things like the government shutdown that we just went through do not help with this, because those are the workers that tend to get furloughed. And so stuff just tends to sit, even though additional claims are still being filed. And so there can be big backlogs and big delays at the charge level. We know that from the time that the right to sue gets issued, then there's additional 90 days that the employee has to bring a lawsuit. So in some instances, by the time you get to actual litigation, which is just the beginning of the actual process, it may have been several years from when the incident occurred. And so in terms of memories and witnesses, some of the employees that may have been involved in that issue or in that investigation may no longer be with the company. I like to say, you may have won the lottery and moved on at that point in time. And so it's important to know that if we don't create the documentation again to show all of our work on this, it really kind of detracts from the integrity of the investigation itself as well. So let's talk a little bit about what triggers the need for an investigation. Clearly, the answer is going to be a typical lawyer response, which is it depends. But there are some general rules of when we know an investigation is going to be required. Any kind of complaint of harassment, discrimination, or retaliation made by or against an employee or a job applicant. Now, one of the words that I'm hearing a lot right now is hostile work environment. It has become a legal term. It was once a legal term that has now become, a commonly used expression for any employee who thinks that their boss is a jerk or has an issue, a grievance with a coworker, and they have a personality conflict, right? And so you'll get, as the HR director, you may get a complaint or an email, this so and so is creating a hostile work environment for me. Now, you may know because you've dealt with this employee and they've been in your office multiple times that this is just more of the same. But it is very important in these situations to get the employee to confirm what they mean when they throw out a term like that. Preferably, that's in writing, but it doesn't have to be. If they won't put it in writing, then you need to get on the phone with them. You need to get their side of the story and then confirm it back in writing to them, which is, you use the term hostile work environment. When we spoke on this date, you told me that really you think she's sabotaging, you by hiding your lunch in the back of the fridge and they can't find it, right? And so, and you told me that beyond that, or beyond, whatever, again, general workplace grievance that this person is airing, that there isn't any other activity that factually that they are concerned about. So don't let those things go unrecognized, even if you can review the face of the complaint itself and make a determination based on it that this doesn't really involve protected activity. This doesn't really involve a hostile work environment, which again is a severe or pervasive culture that is created that is based on someone's status as a member of a protected class. If the boss is an equal opportunity jerk, that is, they treat everyone the same way, they have the same standards, they have the same expectations, then that is something that legally speaking is not going to be a hostile work environment. Doesn't mean that HR doesn't need to address it, but it does mean that it probably falls outside the purview of Title VII or any state human rights act. And so a different level of scrutiny or response or investigation may be required in that case. So those are absolutely going to be circumstances when we have a bona fide harassment, discrimination, retaliation complaint where we need to do some type of investigation. And even if we're not sure whether or not it's a bona fide complaint, we definitely need some follow-up with the complainant and then documenting it in writing what they're actually complaining about, what they mean when they use these terms and throw around things like retaliation or hostile work environment, what they mean when they say that. Why do they feel that way? Are they being treated differently than others? And if so, why do they think that is the case? Are just the critical questions, threshold questions that would need to be answered to know what direction am I going in here and what does this entail? Any kind of allegation of employee misconduct, theft, drug use, workplace violence, or other violation of workplace policy is another circumstance where there may need to be some type of investigation. So just as an example, you may have someone who comes in, causes some type of assault, disturbance, whether they're mouthing off to a supervisor or to a coworker. And let's just say there's an odor of alcohol involved, or we think that they may also be impaired. Okay. In this situation, that's a pretty serious incident that there should be some type of investigation into. in order to make sure that we properly document what happened, because in most cases that individual is going to be losing their job. But if they turn around and say that they were seeking treatment for some type of alcoholism, that might be a situation where we want to make sure that we have those records, even though it may seem obvious that the conduct at issue would violate workplace policies and result in an immediate termination. You still may want to have the witness statements from the people who witnessed it. Let's go ahead and pull the video footage so that we have that and it's properly preserved, because those are the things that tend to, again, memories fade over time. And most companies that do have security footage, if it's not preserved pretty quickly, it tends to be written over, and then lost. So, that would be another situation where, again, some type of investigation, and documentation would be a good thing to consider. Obviously, a workplace accident, there's going to be obligations under OSHA and state counterparts to that to investigate any kind of workplace accident, to prevent reoccurrence, to discipline if necessary, and make sure that we're complying with all safety standards and rules in that area. Any kind of health, again, or safety violation. And then, oftentimes your first notice of something that might be something that needs to be investigated may be in a charge. It may come from the Department of Labor, may come from the EEOC, but we may have had no prior notice of anything before we get a charge. Oftentimes, those involve former employees. But just because someone is a former employee, if they are complaining about something that is ongoing, or a supervisor's treatment towards them of someone who is still employed with the organization, then there certainly would be a reason and an obligation to look into that further. If we don't do it, and then, again, 6 months, 8 months, 10 months later, we get a complaint from a current employee, that could be problematic for the employer to have had prior knowledge of some type of complaint concerning a supervisor and have done nothing about it simply because the complainant was a former employee. Now, it's what we're able to do with former employees may be limited. They may not be willing to talk to us. They may they may be represented by counsel, in which case we can't talk to them. But it still does require some type of action on the part of the employer to do what you can with the information you have. And that may be, limited when we have an anonymous complainant or when we have a former employee. But the answer certainly is never, let's stick our head in the sand and hope that this goes away because this person no longer works for us. So we're going to talk about these types of complaints a little bit more. So, obviously there's direct complaints. It can be written, it can be verbal, it can be in a Teams message or a text message. And, certainly that could come directly from the employee, or it could come from a supervisor. I had an employee the other day who told me XYZ. She doesn't know how to handle it. She doesn't want to come forward. She's afraid. And in our role, HR's role in that is, to say, there is no confidentiality there between you and this employee. I need to know what's going on. You can tell me, or, you and her you can come with her to talk to me about this, but I need to know what's going on so that the company can respond appropriately. So, written or verbal reports, either directly from a complaining party or through a third party, are two of the ways that we may receive this type of information. Again, any kind of use of the phrase hostile work environment is something that would be sufficient to put an employer on notice. Any kind of complaint to a supervisor about inappropriate workplace conduct, the supervisor's knowledge is the company's knowledge. And so making sure that, again, your supervisors have good training and reinforced training on when they need to escalate things to you is particularly important when we talk about investigations. And then any kind of anonymous complaint, would also be sufficient to trigger this. There's also indirect complaints, though, just a supervisor witnessing conduct that could constitute harassment, discrimination, or retaliation. An offhand remark, or knowledge of facts or incidents that are sufficient to show that the employer knew or should have known that something was going on. So there are no magic words when it comes to this. However, as I always say, like if someone's using magic words, then our radar should really be going off. Particularly, you guys are going to start to see it, and you probably already have because I have. With ChatGPT, guys, everyone's a lawyer now, right? We used to be able to kind of read tea leaves and tell when we got an employee complaint if we thought that someone was already represented by counsel just by the wording that they used and the phrasing that they used. And it was just, not always, but oftentimes you could have a pretty good idea just based on how a complaint was presented as if we think someone's already represented or is trying to set us up. Today, anything goes with this ChatGPT. I mean, I think it's getting easier to spot, but it doesn't mean we can disregard it. And it doesn't mean that we can, it means that employees are getting more educated and have more resources and are able to use those buzzwords, which is why, as opposed to downplaying them, we now have even less of a reason or an excuse to turn away from anything that we receive that even if it looks like it was written by ChatGPT, if they're using the buzzwords, it's something that we need to look into and understand. So these things don't always come through formal channels. And this is where I'll also, emphasize how important it is to be reinforcing this with your supervisors. They are the first line of defense. They are the ones who are going to be hearing these complaints or concerns directly most of the time. And so making sure that they know how to issue spot so that things can be escalated and appropriately investigated is important. We don't want them doing these investigations most of the time, okay? If it's a small workplace grievance between two different employees who just have a personality conflict, I'm not saying that's something management should be able to do, but I see oftentimes well-meaning supervisors can end up going out and doing their own investigations without HR's input, which then makes it more challenging for us on the back end of things. And so again, reinforce all of this with training so that these things are appropriately escalated, to your attention. When should a workplace investigation begin? The only answer to this is immediately. And I say that recognizing and understanding how much time these things can take. You may be in the middle of open enrollment or performance review cycles, and you all of a sudden you wind up with a sexual harassment complaint on your desk. But these things need to take priority. For many different reasons. We've already talked about video footage. That is something that there's a very short timeline on. Ordinarily, if you don't know, if your company does use cameras or security footage and you don't know how long it is kept or stored for, reach out to your IT administrator or whoever who's responsible for that and make sure you're aware of it, because oftentimes it can be as short as 48 hours, 72 hours. And so if we learn of something where there could be something that would be captured on footage, there's a very short window of time that we have ordinarily to go ahead and capture that. And so it's important to make sure that you know what that time is so that you can act promptly, even if you haven't had a chance to speak to the complainant or the respondent. Just make sure that footage is captured and preserved. Memories also fade. I can't tell you what I had for lunch yesterday. And that is especially true with witnesses in any type of investigation. So also people talk, right? So if they know that there's an investigation that's ongoing, even if you're telling people, asking people not to do that because it would interfere with the integrity of the investigation, they will talk. In some instances. Now, depending on the circumstances, that in and of itself may warrant some type of disciplinary action by the company. But it is important to kind of protecting the integrity of an investigation itself, that we speak with witnesses promptly to avoid anyone trying to kind of get wind of it and talk amongst themselves. It's also quite often an awkward situation, right? Usually we have an employee who's accusing someone that they work with on a daily basis of doing something to them, or treating them a certain way. And so from that standpoint, we want to, like in a harassment case, obviously, we want to go ahead and institute any interim measures that would be appropriate. We don't want to force that employee to work in the same space with a respondent, if they're not safe doing that. Even if they say they're okay doing it while you're doing the investigation, that is something that is critically important to get in writing from them. I've offered to, let you work from home the rest of the week, or put you on paid vacation while I'm looking into this. But because of the fact that there could be a situation where there are some interim measures being granted, we do not want these to drag on indefinitely. And so that also is another factor for why these things really need to be, it's kind of an all hands on deck situation, where this needs to come priority. And I realize how time consuming that can be, because there's been situations where I've been retained to go in and do some type of internal investigation, and you may spend 2 days interviewing witnesses and another day writing up the report. So particularly because we cannot plan when these things are going to hit, it's important to know that even as inconvenient as it may be, it's very critical to do these quickly, promptly, and then get to a resolution as efficiently as we possibly can. So, what if we don't? I mean, what's the legal ramifications of failing to investigate promptly and effectively? I'll tell you that if I'm in a situation where a lawsuit has been brought, and one of the allegations is that the company did not investigate, failing to have a written report at the end of it that shows what we did and when we did it and how we responded, it really jacks up the settlement value and the risk of exposure on the case. Even if the underlying conduct was not actionable, even if the underlying conduct in and of itself wouldn't have amounted to very much. So this is that important. It's kind of make or break from a case situation. And it definitely impacts the settlement value of any type of cause of action, wrongful termination, harassment, discrimination claim that could be brought against the company. Because it makes it difficult for us to defend these cases absent having a well-documented, prompt investigation to support it. The plaintiff attorney is going to focus on that. Even again, if the underlying conduct was relatively weak and in and of itself may have not amounted to a hostile work environment, right? So what I mean is, even if we don't have conduct that was severe or pervasive, which is an element of any type of hostile work environment claim, if the employer ignored it, turned the other way, didn't document what they did, and it's just a big he said, she said, that's going to be something that really hurts the case. And, the employer is not going to be getting summary judgment. Most likely in those cases, we're going to have to be litigating that or resolving the case before it gets to a jury, because juries expect to see this stuff, guys. If a case is brought and we have you as the HR person on the stand, and you're being asked what you did, and there's no documentation to show for it, and it's been 3 years since you did it, that's on a fast track type of litigation, could be 5 years, probably more likely. Your memory is not going to be great, and that's going to make it really difficult to answer those questions about what exactly happened, what exactly the witness has said, and what the specific recommendations and action items that were taken in response were. So how do we do this? I mean, we've talked about why it's important. We've talked about why it's not optional and what can happen if you don't do it. But how do we go about it? Again, this is the first part of a 2-part series. So we're going to walk through the different elements that I think any effective workplace investigation should have today. And then in December at Tractor Supply, during our in-person chapter meeting, we will actually apply these principles in two different hypothetical scenarios that will kind of, challenge, I think, everyone to kind of apply them in real life type of scenarios. Hopefully not real life, but hypothetical at least. So we talked about the fact it has to be prompt. That's just not an optional element. It also needs to be thorough. Um, and this is one of the things that I think gets looked over, or probably because of how much time these things do take to do in a thorough manner. It's very easy to just go take the employee statement, go talk to the manager. The manager says that's not the way it happened. And then leave it at that and take what the manager is saying, and trust their word over what the employee is saying. And it's going to depend on the case and the factual situation, how deep we need to go in doing one of these investigations. But at minimum, you want to make sure that anyone that's identified as kind of a witness, for instance, if this was a altercation between two different employees, anyone who witnessed it should be interviewed. If there is some type of the complaint is, so and so manager is constantly speaking down to me in different meetings, then it may be important to kind of speak to different employees about their experience and, and establish, really, is this something that is a personality issue, or is it something that is more serious than that? And it will be difficult to know that in a lot of cases simply by talking to the complaining party and the respondent. There may be, again, and you don't want this to become a can of worms. And so I do think that your discretion in each situation, it's difficult to give a guiding principle on what thorough means, because I think it's going to change depending on the specific fact scenario that you have in front of you. By no means do we want to go interview everyone in the company every time that a complaint is made. But that's where the investigator needs to use their discretion to be able to make that determination, which I think happens through experience. The more investigations you do, the more you start to kind of begin to understand, what the appropriate scope would look like in terms of who you need to speak to and what you need to see. It's incredibly important that the person that is conducting the investigation is impartial. And this may be difficult for smaller organizations, depending on the nature of the complaint. It may be that the complaint is made, by the CEO, and it's someone that you report to, and that can just be challenging, right? And so that doesn't mean that you can't be impartial, but this is again why I think having an HR function and someone who can stand in this capacity is important. Now, in some cases, if the complaint is made against you as HR, then you would not be an impartial investigator if you're, which is not a uncommon place for HR to find themselves in, or someone who is in an HR capacity to find themselves in. And so in those cases, we would work with the organization to find out who is the best person to do the investigation. Even if that is someone who doesn't have a ton of experience, with the help of, for instance, outside counsel, it's something that, I've guided board members through doing investigations before, and just kind of, helping them set up the framework for what to do and who to speak to and how to document it and what to do next. Or if it's a serious enough allegation, you could even look at engaging an independent third-party investigator, such as an attorney or HR consultant, to run the investigation, to, again, maintain that appearance of making sure that this is an impartial investigation as well. And that goes hand in hand with the fact that it's objective and well documented. And I'm going to talk in more detail about the documentation piece. So another thing that comes up with investigations oftentimes is confidentiality. We all I believe know that, we cannot in these circumstances guarantee complete confidentiality. It's just impossible. You can't investigate something which is a concern without disclosing certain information about it. But again, that is different from, you know, uh, interviewing everyone in the company. And there's also, different ways of approaching things. So oftentimes where someone has made a complaint about a specific supervisor and their complaint is that this person is just always on me in meetings. They are, always challenging me. They are cutting me off. They are calling me names. I may, in helping with an investigation, we may talk to other people who have been participants in that meeting, but we're not going to start off with a direct question like, have you heard so and so do this? Because then it completely outs that individual and everyone on the team knows. And now it's an awkward situation for everyone involved. Instead, tell me about, your experience. How is the team doing? How does everyone get along? Has anything made you uncomfortable? We start with these general, more taking what I would call like kind of taking everyone's temperature, and then have you ever noticed anyone be singled out, or do you feel like the dynamics are good? If, sometimes that's enough. And in that situation, I haven't necessarily revealed the identity of the complaining party, and I haven't revealed the identity of the respondent. So again, this is going to, how much you can respect and protect confidentiality is going to depend on the specific circumstances of the investigation. But oftentimes there may be two ways to get the same answer. And if you can opt for the road that is less likely to, reveal the identity of those who may be implicated, that's what we want to do when we can do it. Not always possible, but, if we can, that's certainly, the way we want to approach it. It's also important to make sure that the complainant understands that, you will respect their confidentiality to the extent that you can, but that you can't guarantee it in order to investigate. And in some instances, they may say, well, then I don't want you to do anything. It's going to, again, depend on the nature of the complaint as to whether or not that is something that you can agree to or not. If it's harassment, discrimination, retaliation, then the answer is no. I have a legal obligation. The company has a legal obligation to investigate this. And so now that I know it, I have to. Now, if the person then refuses to provide you with any details that you would need in order to actually go forward with something, like let's say they won't tell you the identity of the person or any of the facts. They just say, I think I'm being discriminated against, but they won't tell you who is doing it or what exactly is happening. In those cases, then I think it's impossible for you to really investigate something like that. But what you can do and what you should do is turn around and send the employee something in writing, again, because if it's not in writing, it did not happen. And when I say in writing, I mean a written communication that goes to the employee as opposed to an internal note or file to yourself. That's also very important in these types of situations. So put something in writing to the employee that says, you came into my office, you mentioned that you felt that you had been subjected to discrimination. I asked you for details about that. You refused to provide them to me. My door is open in order to, the company prohibits discrimination. We prohibit retaliation. We have an obligation to investigate these things, but without you providing me the details, I really have no ability to do so. If you change your mind, the door is open, right? In that case, at least you have something that we can use if the employee later on turns around and files a charge of discrimination, says they complained about discrimination and nothing happened, the company did nothing. You can point back to the email where you indicated, we can't do anything because you won't tell us anything, but we encourage you to come forward and let us know so that we can take a prompt and effective action to address your concern. So, that's just one example of where the documentation is make or break on summary judgment versus some he said, she said factual dispute, which is going to have to go to a jury about whether or not the employee complained and whether or not the company did anything in response. Evaluating the evidence is another piece that I think companies can struggle with in the course of doing these investigations. Remember, you don't necessarily have to get it right, but you do have to reach a conclusion. And that will often include evaluating evidence, including the credibility of whoever is the one, the people that you're interviewing. You know, you're going to be looking at bias, motive, and just credibility. And so I also think that that is something that we'll talk about a little bit more on the documentation, but it's tempting as a company to say, oh, we couldn't make a decision one way or another. But oftentimes, I think you're going to be able to reach some conclusion. You know, it may not be that you were able to say that that their exact complaint was substantiated, but you can reach some type of conclusion and shouldn't be afraid to do so, because that's exactly what you're being tasked with doing when you are in the role of an investigator, is to make those judgment decisions and those credibility decisions. That goes hand in hand with actually reaching a conclusion. And then we're going to talk about communicating results when we talk about documentation, because that I think is something that gets frequently neglected in this process. So once again, when we're talking about the investigation, I don't want you to take from this that every time that there's something that lands on your desk, we need a full-blown investigation, all hands on deck. We're interviewing the entire company, and then we're going to spend 3 days writing a report. I understand that's not practical. So we need to look at, again, is there a potential for legal exposure here? Is this discrimination, harassment, or retaliation? If so, that should immediately kind of trigger a higher level of review. If it's a serious violation of company policy versus a minor infraction, you know, again, that would be something that would warrant a more serious investigation. You know, if you're in a highly regulated industry and this involves something that would involve some type of violation of laws that are applicable to your industry, you know, again, if you have regulators or auditors or other third parties that are looking at these things, those would be things that would suggest we absolutely need to make sure that we are looking at this and documenting it appropriately. Listen, some cases here, this is also outside our purview. And I think it's important to highlight that if we're dealing with, a report of a weapon on company property or drugs on company property, or some type of, other illegal activity, that's what the law enforcement is for. And so those are situations where you absolutely should not go investigating things without involving law enforcement. And if you're ever in doubt as to that and whether or not it's appropriate to involve law enforcement, this could be a 5-minute call to your attorney to get some very quick guidance on how to proceed. So choosing the investigator, I talked about this a little bit, but I do want to kind of hit on, again, just making sure that this person had, in an ideal situation, would have knowledge of the relevant law, would have done this before, not their first rodeo, ability to exercise independent judgment, and not someone who is involved in the underlying misconduct. In a biased investigation is, almost as bad as not doing one at all, if it's pretty obvious that the person is involved, and things of that nature. So again, likelihood of litigation, that might be something that would trigger the need to involve outside counsel. The other reason that companies often do that is to maintain some type of privilege. If we think that there could be, again, regulatory action or some type of administrative action or activity that could result, or even some type of criminal white collar activity, those would be situations where involving your attorneys early and having them be the ones to guide the investigation is often a smart consideration, or because, otherwise all of the documentation that you're doing is going to be discoverable. And there are sometimes and oftentimes in employment cases where we'll receive a lawsuit and we actually want to go ahead and disclose the results of that investigation to the other side because it shows that we reacted promptly and effectively and looked into the concerns, and it actually helps the company's defense. However, that is a decision that you don't have the ability to make that decision if you don't involve your attorneys at the front end of it, because we cannot cloak with attorney-client privilege an investigation after it's already been conducted by you internally. So if you think it's something where we have, again, serious liability, egregious allegations, or even a small company, but it's at the CEO level or the C-suite level, and for that reason, we think it's important to go ahead and involve counsel, it's certainly worth at least having that discussion and weighing the pros and cons. What is the cost of having counsel step in and do this versus, the potential exposure if we don't, and having an investigation that may make some pretty damning findings against the company that is a discoverable document. So definitely something to think about depending, again, on the nature of the investigation and the complaint that we are dealing with. You don't want to just rush in and start interviewing people. You want to have a plan. What is being asserted? Who do I need to speak to prove or disprove that? Who would have relevant knowledge? What documents would I want to see in order to prove or disprove this? And then what order, do I want to go in? And this is, again, going to depend on the facts of every situation. There are some schools of thought that say in every case, you have to talk to the respondent. Unless you're a private employer or a public employer, rather, there's some type of due process involved. If I have someone dead to rights on something where I don't really believe in those situations that it is always necessary to talk to the respondent. If it was he came in and spit in somebody's face and we have 5 people that witnessed it, I don't really care why he did it. In those situations, it's going to be an immediate termination in most of the cases. But again, these are all highly fact dependent on the situation that you have. In most cases, you will want to talk to the respondent. You will want to get their side of the story. And even if it's just for them to admit to whatever the conduct at issue is, that's always beneficial as well in these. So all of this should begin with kind of some type of game plan. When you're conducting the interviews, you do definitely want to emphasize that the company prohibits retaliation because oftentimes, again, I think more often than not, we have a complaint where the underlying conduct is not substantiated, but then someone does something that appears retaliatory. And if that makes it to my desk or I get that phone call, I am more likely to recommend that we deal with the retaliation more harshly and severely in terms of disciplinary action than we would the underlying conduct, because I think that's a zero tolerance situation when we have any type of appearance of retaliation in an investigation situation. So you want to make sure that the interviewee understands that. They should also really understand that this isn't optional for them. If they're a witness, and this may depend on, again, how serious the issue is that you are investigating, nobody wants to be involved, but this isn't a choice. And your handbook and your policy should state that the employees have an obligation to cooperate with the company when it comes to investigating any wrongdoing. And if they're refusing to, or we get, then usually reminding them that this is something that is, required by company policy. And, we can, again, protect them from retaliation, but we do need their cooperation. And failing to cooperate or refusing to cooperate with a workplace investigation is something that in and of itself could subject the employee to disciplinary action. So again, I think you have to exercise discretion about how hard you want to push on that, or how far you want to take it. But oftentimes I'll get a call from an employer that's like, well, Bob didn't want to tell me anything. He didn't really have anything to say. I'm like, well, did Bob understand that this wasn't really optional for him? And sometimes the answer to that is no, I wasn't sure. So just make sure your employees understand that. You may also want to, the location of the interview is important. If we're dealing with something sensitive, you may decide to have interviews off-site. It makes employees feel safer. What you don't want to do is do them in a conspicuous, wide open area where there's, for instance, like our conference rooms are all glass, and so there's a bunch of people walking back and forth, and everyone sees that you're in there as HR doing these investigations and doing these interviews, and word is going to travel pretty fast and people are going to be pretty uncomfortable. I do think it's important. And one thing I'll note with Zoom right now is I think it's critically important when you're doing an investigation to be able to see the people that you are talking to. And so ideally, these would occur in person, any interviews. If that's not possible because they're remote, then Zoom is fine, but I would make sure that they have their camera on and that they know that they need to have their camera on and they're in a position where they can. And that goes back to assessing credibility. Someone's body language, someone's eye contact, how they're responding to those questions. There is a lot of nonverbal cues that people will give off. And if you cannot see their face as an investigator when you're asking these questions and needing to kind of get solid answers from them, it makes it very difficult to assess those nonverbal cues. So I would, if they don't have their cameras turned on and it does have to be remote, I would prompt them to do so. And if they refuse to do so, I would take note of that as well. Because when you're acting in the capacity of an investigator, you're really trying to get to the truth and trying to find the facts. And if someone's not being cooperative with the requests that you are making with them, that is, again, it goes back to their credibility. Go in ahead of time with having, an outline of the items that you want to address with each witness. You also, in general, want to utilize open-ended questioning. So, you want to get a sense of who, what, where, when, how, and then take those from those general questions, you will go more and more narrow. So, let's just take an example of a hostile work environment complaint. Tell me about the first time, you can recall feeling like you were singled out by your supervisor, and then from there, what did they do? Did anyone witness it? Is there any supporting documentation for it? When was it? Where did it occur? Okay, tell me about the next, what after that initial incident, when was the next time? And you really just want to walk chronologically, starting with general questions, narrowing in. Why did you feel that way? What did he say that specifically? Or did you assume that that was what was said? Ask those follow-up questions as needed to really get a good sense of what the witness is saying. Definitely make sure that you ask for any supporting documentation that is referenced, especially with all of the Teams and the Slacks and the other messaging platforms we have right now. It is incredibly difficult to go and try to retrieve and search for that information. If we wait until litigation is filed to gather it. It's also extremely expensive to try to recover that type of ESI. So go ahead and get all of that on the front end or confirm that there isn't anything that needs to be gathered. And then make sure that the interviews are documented and you conduct the follow-up interviews as needed. Investigations tend to take on a life of their own. And so whoever you start with and thinking these are the people I need to speak to, if there are additional names that are brought up during the investigation where that person has material information that may help you, don't stay confined or get, kind of blinders on about how you go about it. Don't be afraid to go and ask for that follow-up if needed or circle back with even someone that you had already spoken to if needed. So that's important. Once you've done your interviews, generally speaking, or even before you do your interviews, you may want to gather all of the relevant documents and other evidence, and then evaluate it. So, the investigation doesn't serve any purpose unless you can make a evidence-based determination that relies on the interviews, documents, and other evidence that you collected. You want to then again assess that witness credibility and weigh any conflicting or corroborating evidence that you may have gathered. And this is also a good place to just kind of, even if you've been doing the investigation, calling your lawyer and saying, hey, I have this investigation. Here's what Susie said. Here's what Bob said. Here's what the documents say, and just having a discussion with them about what you're thinking in terms of your findings and how to document them and what is supported. Might be a 15-minute call, but would be extremely beneficial to giving you, I guess, a little bit of confidence in the decisions and recommendations that you're making. The report here is critical because, again, going back to the beginning of this webinar, none of this matters if we have nothing to show for it and can't prove that we did it at the end of the day. And this is most often where I see companies kind of fall short, and it makes sense. And it's because these things take so much time. So by the time you've kind of figured everything out, you've spoken to Susie, you've spoken to Bob, you've looked at the other witnesses, and you feel like you have a good sense of what's going on, sitting down and typing all of that up is extremely time consuming. And so I don't fault any of us. I'm guilty of it myself. But this is the most important part, is making sure that that is documented. And you really have to do it close in time to when your findings were, or you as the investigator, your memories will fade, and all of that. So make sure that that is not overlooked in this, or, all of that hard work and all of that fact finding is kind of lost if we don't put it together and document the summary that's taken. Obviously, we need to take appropriate corrective action that is based on the results of the investigation. Generally speaking, the investigator should not be the person that is involved in final disciplinary decisions, because that goes back to impartiality. So you may make findings and recommendations, but you don't want to be the one who's deciding the outcome of the investigation. That should go back over to, whatever decision makers would be appropriate given the employees and issues involved. Even if the evidence is inconclusive, most of the time an investigation will tell you something. It will tell you, oftentimes, for just to use an example of a harassment case. Well, something happened on social media and the employee complained about it and they delayed in bringing it forward. And you ask them during the investigation, why didn't you bring this up? And they say, I didn't understand that stuff that happened on social media was prohibited by company policy. So even if, again, that's just something that you can kind of take and note and like, whoa, we can increase our training on that. We need to make sure we're hitting that harder because, this is something that maybe if it wasn't directly related, but it's something that, comes out of the course of the investigation that lets you know we need to do a better job on training, because if our employees are not understanding our policies and how they apply, that's not something we want. Communicating the results. This is second to the investigation report. The second thing that I see that just does not happen and is so easy to do and so important to do. If we don't communicate with employees in writing about the results of these investigations, they don't, again, if it's not in writing, it didn't happen. Here's another important note. The employee may have used the words harassment, discrimination, hostile work environment. I do not want any of you to be using those words, not in your investigation report, not in communicating the results. Those are legal terms of art, and those are legal decisions. And if we use those terms in the investigation report or in communicating outcomes, they could be considered admissions of liability. So instead, I would prefer to use words like complained of conduct that may violate this policy. We were able to substantiate the complaint regarding, misconduct and in violation of our policies. Pull it back to your policies. Don't use legal terms when you're, putting things in writing about these complaints, these types of complaints, particularly if it's discrimination, harassment, retaliation. So keep that in mind. Very, very important. I see it happen a lot. We don't want to adopt the employee's characterization of the nature of the complaint. But do, communicate the results. We were able to substantiate it, or we were not. Here's what we've done. And often you will not be able to tell the employee actions that have been taken or specific actions that are being taken, because that would involve another employee and you're not going to get into that. But you can say, we have taken appropriate action. And if there's anything that you feel is retaliation, we want to know about it. So something can be said. Make sure then that you've done all that hard work. Make sure that you maintain that documentation. Also very, very important, because, again, if you win the lottery and move on, and if it was stored somewhere on your desktop and your computer gets wiped, we have no record of it. So make sure that any kind of underlying documentation, interview notes, investigation report, copies of the letters that were sent to the complainant and the respondent are kept. They don't go into personnel files. They should be in a separate, confidential file where access is restricted. And make sure that you have that. Again, if it's conducted internally, it's going to be discoverable in the event of litigation. That's not necessarily a bad thing, but it's something you need to be aware of, and it should definitely guide and inform how you are documenting the entire process. And then if it's conducted discoverable by counsel, it may be discoverable, but more likely you have a stronger claim that that's subject to attorney-client privilege, and it's not discoverable unless the company elects to waive the privilege. So I have a few more slides here, but I'm pretty sure we have hit on all of them. These are common mistakes here: promising complete confidentiality, taking the side of one of the parties, not documenting, not actually conducting an active investigation. All of these are things that we have talked about today and are, super important to making sure that these are thorough, and objective, and, do what you need them to do. Failing to arrive at a conclusion, we talked about that as well. And I see it very often that people resist this, resist wanting to do that. But don't be afraid to kind of lean into that. And then I think we're at time. So if anyone, has questions, I'm happy to stay on and answer them. I think there's a few right here, maybe not. Let's see. Union question. Yeah, unions are a completely different beast. I mean, you got to look at your CBA. The specific question here is, are you obligated to share the documents with the union? And I think that is something that you would need to look at the specific requirements under the collective bargaining agreement. And it may depend on the type of investigation as well, but definitely seek legal counsel on that. And then the last question here that I'll hit is it illegal for a supervisor to tell an employee, I wish you'd quit? I don't think that's illegal in and of itself, which is good. But still not best practice maybe for your supervisors. So, all right. Thank you everyone for joining today. Please come on December 4th at Tractor Supply for our in-person workshop, where we are going to take the things that we have talked about here today and then apply them to some hypothetical examples and kind of work through how these things play out and how to respond as different facts change during the course of an investigation. All right. Thank you so much.